So let's get underway here. So call to the meeting to order. Welcome to meeting number 21 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference of February 2nd, 2026, the committee is meeting to begin its study of Bill C-16, an act to amend certain acts in relation to criminal and correctional matters, child protection, gender-based violence, delays, and other measures. Today's meeting is taking place in hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using the Zoom application. I'd like to confirm the sound tests were done successfully. Everybody knows the guidelines that are in front of them on the desks, of course. And then I would like to make a few comments for the benefit of witnesses and members. Please wait till I recognize you by name before speaking. For those participating by video conference, Mr. Housefather, you know the routine. I don't think I need to go through all of the details. So I will skip that, and I will jump to welcoming our witnesses. First of all, we have the Honourable Sean Fraser, Minister of Justice and Attorney General of Canada. Welcome, Minister. Thank you for attending today. The Minister will be with us for the first hour. He's joined today by Department of Justice officials, Owen Ripley, Senior Assistant Deputy Minister, Policy Sector, Matthew Taylor, Senior General Counsel and Director General, Criminal Law Policy Section, Natalie Levman, Senior Counsel, Criminal Law Policy Section. Minister, I will turn the floor over to yours for your opening comments, and thank you for being here.
Oh, and how long, Mr. Chair, for opening comments?
He has 10-minute max.
Okay, I will endeavor to be shorter than that to leave more time for questions. Thank you. Thank you, Chair and colleagues, for being here at committee to discuss Bill C-16, the Protecting Victims Act. This is an important piece of legislation that I do believe is going to improve safety outcomes in a number of different contexts, including gender-based violence and the protection of kids online, in addition to certain other changes that will, in my view, strengthen the capacity of the justice system to respond to pressing social challenges. Juste avant de commencer, je pense...
Before I begin, I think it would be useful to give a bit of context about this bill and how it was sent to the committee. We have a strategy to protect the public and enhance public safety. The strategy includes three categories.
Strengthen criminal law reforms to ensure that we have laws in the criminal code that are designed to enhance public safety and ensure that serious crimes are met with serious punishments. The second pillar of this strategy is really focused on supporting the front line. This could include 1,000 new RCMP officers, 1,000 new border officials, but it also includes giving law enforcement the tools that they need, whether that is more recently Bill C-22 or other authorities that will help them investigate, prosecute, and protect the public against crime through prevention efforts. The final pillar of the strategy is really on making the upstream investments to help build healthier communities and healthier people in the long term. This is where we're talking about investments in mental health and addictions, affordable housing, in programs that target at-risk youth to ensure that as you build healthier people and healthier communities, you have a long-term opportunity to reduce violent crime in Canada. Today's bill really falls under that first pillar, strengthening criminal laws in this country. There's a number of different themes that I hope to draw your attention to. Of course, there are several dozen different measures in this bill, I believe 83 distinct changes, but I'm going to focus on a few key ones.
First of all, I want to talk about the importance of addressing femicide in this country. When I read stories in the newspaper about, 7 femicides in Quebec alone this year, I thought it was a real tragedy. We need to take action to fight femicide, not only in Quebec, but all across the country.
Injustice taking place in this country when it comes to the murder of women, often at the hands of their intimate partner. We have an opportunity to respond by creating a constructive first-degree murder charge in cases of feminicide. This will include murders that are committed in certain different contexts, including hatred-motivated murders, where someone is targeting a victim, for example, on the basis of their gender. This also includes murders that will be committed in the context of coercive and controlling controlling relationship. It will also include murders that are committed in the context of the commission of a sexual offense. I do want to pause on the issue of coercive control for a moment, because in addition to it being a qualifier for that first-degree, constructive first-degree charge in cases of feminicide, we've made the decision in this bill to move forward with the criminalization of coercive control as a standalone offense. We want to do this because we have an opportunity to have the justice system intervene before a relationship becomes violent and before violence becomes fatal. We have seen through our engagement in the preparation of this bill, time and time again, those who have spent their lives and careers studying the issue, citing coercive and controlling behavior as being predictive in terms of future violence that may take place in the household. We are not talking about ordinary facets of a healthy relationship. We are not talking about arguments over who's going to manage the household finances. We are talking about behaviors that would reasonably cause a person to fear for their physical or psychological safety. In addition, this bill makes changes to the charge of criminal harassment, ensuring that it's both modernized for new technologies, but also that we've shifted the test towards an objective rather than subjective standard, given the feedback that we heard about how difficult it can be for victims of criminal harassment to actually demonstrate what they in fact felt rather than what a reasonable person would feel in the circumstances. There are a number of other issues in this bill that I want to draw your attention to, including the creation of a number of new sexual offences. In particular, I direct you to portions of the bill that speak to changes in regards of Canada's criminal laws insofar as they impact the distribution of intimate images. We are changing the law in two key ways that I'd like to focus on. One is to ensure that the criminalization applies not only to the distribution of these intimate images without consent, but also the threatened distribution of those images. There's one other feature that has found itself in the news for perhaps obvious reasons. Our laws need to have the ability to keep pace with changing technologies in this country. We've seen a preponderance of cases making their way through our communities, into the newspapers, and occasionally our courts, involving the use of artificial intelligence to create deep fakes of intimate images that bear the likeness of a person known to the prospective offender. I say prospective because the criminal code does not necessarily recognize today the use of AI deep fakes the same way that it would intimate images that are captured through other technologies. In my home province of Nova Scotia, very recently, we have seen a judge dismiss charges against an accused person on the basis not that the act was not heinous or morally culpable, but that the criminal code does not include within the definition of intimate images those which are created through the use of artificial intelligence. This bill proposes to change that, to deliver justice to victims who are having their likeness used for such an inappropriate and morally culpable reason. And with the modernization of the criminal code, we will be able to ensure that these behaviors are captured and that the wrongdoers are punished for their actions. In addition to certain new sexual offences that are being established, we also are going to be increasing the penalties for certain sexual crimes, including voyeurism, summary sexual assault. We will be looking at a number of other matters when it comes to sentencing as well. By and large, these changes are made to provide equity as between existing provisions within the code to align the maximum sentences in some charges with the maximum sentences that pertain to other charges that take place in a sexual context as well. While we're on the subject of expanding the maximum penalties, this bill also takes significant steps to restore mandatory minimum penalties for a wide variety of crimes where a mandatory minimum penalty has either been struck down or where it maintains its place within the criminal code today, but carries with it constitutional vulnerability as a result of the treatment by the court of mandatory minimums that existed previously. Now, this is a response very directly to the Senville decision that we've seen from the Supreme Court, and we've made the decision to restore these mandatory minimums, but take the court's direction with the creation of a safety valve only for those circumstances where the mandatory minimum would be grossly disproportionate. It's important that we ensure we have the constitutionality protected of these provisions if we actually want the provisions to be useful. The provisions that exist today are offering no protection to anyone because the court has indicated that they will be struck down when challenged. We have found a way that not only reflects the feedback included in decisions of the Supreme Court, but part of the reason we chose this particular approach was the public statements that we've seen in the House of Commons and elsewhere from members of both the Conservative Party of Canada and the Bloc Québécois. Our desire was to find a path forward that would gain multi-partisan support to ensure we could address this particular issue professionally and in a way that would carry the test of time. There were other strategies that we've looked at, but for reasons that I'm happy to get into for questions, we've chosen to move forward with the strategy outlined in the bill itself. There are other changes that we made as well, particularly to protect kids against exploitation, including in an online environment. This includes changes to sextortion, including not only the distribution, but as I mentioned in the context of intimate images, the threatened distribution of child sexual abuse material. It also involves changes to child luring provisions within the code to ensure that they are incorporated within the definition of sextortion for the purpose of this bill. There's a series of other penalties that range from depicting bestiality to inviting exposure to a series of other measures that impact on mandatory reporting and other facets. But suffice it to say, we've taken feedback from stakeholders who have made it their life's work to protect victims. Mr. Chair, I have one item I'd like to complete before I finish with the time that I've been allotted, and that's on the issue of delays in the court process. We've seen over the last number of years, according to news reports, nearly 10,000 cases that have been dismissed for delay, not because a trial has come to its conclusion and had a not guilty verdict rendered, but instead stays of proceedings issued. This often comes up in complex drug investigations, but it also comes up often in sexual assault contexts. And it's never felt like justice to me that the potential perpetrator of a crime would benefit from a stay allowing them to live in the same community where the victim resides. This bill proposes to address this challenge in a number of different ways. One, by addressing delays directly by seeking to streamline procedure, but others in other ways to encourage the court to use a lengthened timeline for complex cases, but as well, when that time is hit, to consider remedies other than a stay of proceedings. Monsieur le Président, je pense que c'est un proche de 10.
Chair, I believe I'm close to the 10-minute mark, so I'd be happy now to give you the floor so that I can take some questions from committee members. Thank you.
Thank you very much, Minister. Okay, we'll start the first 6-minute round with Mr. Brock.
Thank you, Chair, and thank you, Minister, for your attendance as well as your officials from the department. Minister, after a decade of catch and release Liberal bail, repealing mandatory minimum penalties, and other hug-a-thug laws, Canadians are understandably scared. Since 2015, human trafficking has increased by 84%, sex assaults are up almost 76%, violent crime up almost 55%. C-16 egregiously continues the Liberal soft on crime agenda by empowering judges now to ignore literally every mandatory prison sentence in the criminal code other than murder and treason. Liberals are now trying to allow judges to ignore them for aggravated assault with a gun, human trafficking, and multiple firearm offenses, including extortion with a firearm, weapons trafficking, drive-by shootings with a restricted or prohibited firearm, and more. Parliament ministers sets mandatory minimums for these heinous crimes for a reason. But if your government allows judges to ignore them, there will be nothing mandatory about it, period, full stop. The passage of this provision would be a total abrogation of our duty as elected representatives to keep our communities safe. Conservatives will never vote for lighter sentences for serious offenders. Will your government immediately split off this poison pill so we can all get back to work making this bill better and keeping Canadians safe?
Thank you, Mr. Chair. And I have respectfully a different point of view from my honourable colleague in terms of the value that this bill is going to offer more broadly. I take the closing comment in his question as a endorsement at least of some measures within the bill, if not the provisions that apply to mandatory minimum penalties. On the issue of mandatory minimum penalties, though, there's a particular piece of context that we need to understand. Because I know the member asking the question believes that the government should adopt laws to protect against the harms he's enumerated. I share that desire, sincerely. We all want strong penalties for serious crimes. But we have to ask ourselves, what value is a mandatory minimum that exists on paper that is not recognized by law after decisions by the court striking down those mandatory minimums? If our laws written into the code are not enjoyed in our communities, then those laws are not with the paper, are not worth the paper on which they are written. Today, the mandatory minimums that include those that were subject to the Senville decision offer no force of protection for Canadian victims. We might feel good about what the code says, but if the court is going to strike down those provisions and not incorporate them into the sentencing regime, we can't say that there is a functioning mandatory minimum regime today. We made a decision to restore those mandatory minimums, taking the constitutional guidance from the court, so they will actually be put in place and will demand reasons from the court in circumstances where they deviate from the mandatory minimum. Keep in mind, we're not dealing with some widespread discretion. We're dealing with circumstances that are so excessive as to outrage standards of decency, in the court's words, or that would be intolerable to society. We think we found the right approach.
Thank you, Minister. A glaring omission in Bill C-16 is the lack of reintroduction of the 15 offenses that your government, that you voted for, Minister, in the passage of C-5 in the 44th Parliament. Will your government reintroduce all those mandatory minimum penalties for those offenses that were removed?
Mr. Chair, one just sort of historical development piece of this bill that's important to understand is the Senville decision arrived as we were preparing the contents of this bill. We made the decision to respond, and we thought it best to address the issue of mandatory minimums that existed today, that were baked into the code previously, including those that remain in the code and those that were struck down. We didn't do a full-blown consultation about either provisions that had been removed by Parliament or those which could potentially be added or removed from a mandatory minimum regime. If that's an issue that this committee would like to study to provide guidance, I would welcome that guidance, but it would be important to actually conduct that consultation.
Only reason I raise this is your predecessor, David Lametti, was very proud of the fact that mandatory minimum penalties do not work. In fact, he's quoted numerous times, and the quotes have not aged well over time, given the rising crime levels in this country. But I put to him the very possibility that the Supreme Court of Canada could be upholding mandatory minimum penalties that C-5 removed. I raised that as an issue, and sure enough, after royal assent of C-5, the Supreme Court of Canada in the Hill and Hillback joint decision upheld the mandatory minimum penalty that was removed by C-5. So, given the Supreme Court of Canada has upheld a number of mandatory minimum penalties that have been in the existence of the criminal code since the late 1800s, why would this government not take an opportunity? The 15 classes of offenses that you removed in C-5 are very significant violent offenses, including every single drug offense under the Controlled Drugs and Substances Act. Why wouldn't this government take an opportunity to strengthen our criminal laws as opposed to weaken it?
So I don't view Bill C-16 to weaken Canada's criminal law for the reasons that I've articulated in the opening set of remarks. It strengthens them in a number of particular ways. Back to the question that you've asked, when we were moving forward with the decision to address the consequences of the Senville decision, we were dealing with the umbrella analysis around the protection of mandatory minimum penalties as across offences. We did not do
yourself, Minister?
All right, Mr. Brock, you're actually out of time. I was just allowing me an opportunity to answer your question. So.
Thank you.
happy to address further in response to subject.
If you want to finish your answer.
Look, only that if you're going to add or subtract particular offenses from a regime that purports to impose mandatory minimum penalties, you should appropriately engage with stakeholders, with experts, with law enforcement to understand which provisions are going to have the most meaningful impact. That would be an excellent task for this committee to take on should you wish Mr. Brock to make further recommendations. Having not done that policy work, given that it was outside of the scope of the initial intended range of measures included in the bill, I don't think it would be appropriate to start adding new offences to that regime without that policy work being done in advance.
Thank you, Minister. Thank you, Mr. Brock. Mr. Chang, 6 minutes.
Thank you, Mr. Chair. Thank you, Mr. Minister, for being here and for your leadership on this important legislation. Bill C-16, the Protecting Victim Act, reflects our shared responsibility to ensuring that victims are better protected and supported within our judicial systems. Canadians expect a system that's fair, compassionate, and responsive to those who have been harmed. In my riding of Burnaby Central, many of my constituents have shared their concerns about safety, accountability, and the need to better protect vulnerable people, particularly those, particularly in the face of evolving threats. I appreciate the work that has gone into this bill and the focus on strengthening public confidence while upholding the rule of law. With that in mind, Mr., could you begin by outlining the main purpose of Bill C-16 and why the government believes that the reforms are necessary at this time to better protect victims and vulnerable people?
Certainly, and it's a bit of a complex question to unpack because there's a number of different policy areas that this bill does cover, and the motivation between within each policy area may be slightly different. If I could maybe boil it down for the purpose of simplification, a significant portion of the energy that's been dedicated in this bill is really focused on the problems that we're seeing with intimate partner violence in this country. It's egregious to me, the level of violence that we are seeing facing Canadian women and the routine nature in which we see stories in our newspapers where that violence is perpetrated by too often a man who is in a relationship with the victim. When we hear calls for the government to take action to address femicide more squarely, we're not dealing with a philosophical issue. We're dealing with cries for help from families members who are dealing with the years not lived of their most closely held loved ones. When we're dealing with coercive control, we are hearing from women who may have escaped violence, hoping that they can offer protection to other women who are in similar circumstances. When we hear about the need to change the laws around criminal harassment, we're responding to very real calls for action where people have gone through the process but been unable to meet an evidentiary standard, notwithstanding the fact that they've not been able to live safely in their communities. Similarly, with the mandatory minimum penalty regime, we want it to deal with the world that we actually live in, not some hypothetical version of it where we can ignore the decisions that were taken by the courts, which we have an obligation to respect as elected officials. We wanted to ensure that we had those mandatory minimums in place to say there will be serious consequences for serious crimes, while we respect the nature of the court's decision with respect to safety valves for those circumstances that would result in a consequence that the public would find intolerable. There are other changes that were motivated with shifting technology, again on criminal harassment and AI deepfakes, making sure that our motivation is to offer protections that we always thought would exist, but recognizing that the laws need to be updated to reflect modern tools that are being used to commit morally culpable behavior that may be outside of the definition of the crime. And finally, because I don't want to eat up all of your time, Mr. Chang, the prevalence and expanding rate of exploitation of children online is something that we need to address. As a parent, I have grave concerns about the ability of people who would do harm to engage with kids the age of mine. We have to adopt protections that will recognize that these heinous behaviors take place in our communities and offer protections against them. We can't lose sight of the fact that this bill is one part of a larger, broader strategy that will seek to end violent crime in our communities, but those are the kinds of motivations that justify the introduction of this bill.
Thank you, Mr. As technology continues to evolve, we have been seeing new forms of harms emerge. Could you outline the bill, how Bill 16 updates the criminal code to respond to crimes such as extortion and the creation and distribution of sexual deepfake?
Yeah, well, look, let's dig in on this issue. There's been a couple of decisions rendered by courts that point out the fact that the use of AI deepfakes to create intimate images without the consent of the subject of that image is a horrible behavior that demands action. It's rare that the courts will so clearly point out the need for legislative change to address a particular social harm that they witness and agree is bad, but cannot do anything about because courts recognize the limit of their jurisdiction does not extend to rewriting the offenses included in the criminal code. We have an obligation to respond when people are using new technologies to commit old crimes. We have to update our laws to reflect the changing nature of technology. It's not just present, by the way, on the use of AI deepfakes when it comes to intimate images. It's also present when you're looking at criminal harassment, when people are increasingly using cell phones to track the whereabouts of their partner without their knowledge, potentially. You also see people threatening to distribute through online means child sexual exploitation and abuse material. If we don't update our laws to reflect the changing nature of technology, we might feel very good about ourselves for what's written on paper until we learn about the severe harm that's befalling innocent Canadians that could have otherwise been prevented.
Thank you, Minister. Many stakeholders and community organizations have called for stronger tools to deal with intimate partner violence and coercive control. Could you speak as to how Bill 16 responds to those calls and why the measures are so important?
Certainly. So I addressed in my opening remarks some of the changes that we're making to femicide, creating a constructive first-degree murder charge to demonstrate that we will take hate-motivated murder as seriously as any other crime in the code, that we will deal with murder committed in the context of a sexual offense as seriously as any other crime in the code. We want to demonstrate to Canadians that we will not tolerate this kind of this most heinous version of murder that exists. But we also want to not just focus on punishing crime after it takes place, but potentially having the justice system intervene earlier in the process. This is where changes to the new offense of coercive control come in. When you know that there is certain behavior that is predictive of violence, potentially predictive of fatal violence, we have an opportunity to intervene that would lead to criminal charges for the offensive behaviors that we know often precede violence, that often precede murder. So when we have an opportunity to address these kinds of needs, we must take that chance. I should, by the way, take the opportunity to offer my thanks for the collaboration of Mr. Caputo on his private member's bill, which complements some of the measures included in Bill C-16 in response to a horrific tragedy that came out of British Columbia, the case of Bailey McCourt. When we work together across party lines to address a problem of common concern, we can offer more protections for vulnerable people.
Thank you. Mr. Fortin, for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Minister, good morning. At the Bloc Québécois, we read this bill, and we're fairly open to it. We think that there will be some amendments to bring forward, but overall we think it's a good bill. Now, I have a few questions. The question of calculating judicial delays. We all agree that I think we all agree, the Supreme Court was right to say that 2 years for provincial court cases or 3 years for superior court cases are reasonable limits. And we should be able to, conclude a trial within that time frame. However, there were people accused of violent crimes, really heinous crimes, and these people have been released because they were not able to finish their trial within a reasonable time frame. It just doesn't make sense. We need to do something about it. Now, as Minister of Justice, this directly concerns you. The Bloc Québécois tabled a bill in the previous Parliament that essentially said for serious crimes, violent crimes, there could be an exemption to that timeline. And there could be a new provision in the criminal code saying that, in circumstances where you had these violent crimes, there should be an exemption. Unfortunately, that bill died on the order paper when Parliament was adjourned last spring. And we end up today with a new proposal that essentially would recalculate how those delays or would change how the delays are calculated. So I'm not sure that's the best approach. I'm wondering, Minister, if it would not be better to have a similar provision to what we were proposing that would allow the courts to use a Section 33 exemption to change those limits in extreme cases when it really is necessary, to say that those Jordan ceilings do not apply. Do you think that would be a good idea? I have a different approach, but I agree with the idea that we need to address particular circumstances when the trial ends without a verdict. But there are two strategies within this bill to deal with delays in general, first of all. Now, we agree, delays are a problem. In cases where Jordan ceilings apply, these are often complex cases. But, delays don't provide justice to the victim or to society as a whole. To address the situation, we are proposing new rules
time to trial, procedurally to address the underlying problem of delay. Separately, we're also trying to deal with the consequence, not only by calculating time in a particular way or excluding certain applications, but by directing the court to consider remedies other than a stay. I prefer this approach to using Section 33. I think it is cleaner and has an opportunity to address the situation. But if the committee has an opportunity to engage on the best way to address the delay issue, I would welcome the feedback of this committee and for those in the Senate who may be watching. I really do believe in the process of Parliament, and I would welcome testimony supported by expert witnesses as to the best way to address delays. But the approach laid out in C-16 was my preferred strategy.
J'avoue que j'aime bien moi aussi cette idée-là de...
I also like the idea of tightening the rules to avoid, whenever possible, having trials end without a verdict, particularly in the extreme cases. But nonetheless, there are situations where that won't be possible. And even if we would dearly wish for it to be the case, it won't be. When we talk about reasonable delays, the idea is not only to benefit the victim, but the accused as well. If the accused is innocent and it takes 5 years for the ruling, well, that's not good. And if he's guilty and it takes 5 years, it's not good for the victim. And it also has an impact on how things are calculated. So no one wins. It's expensive, it's long, no one wins. So again, if you have an extreme case where you've studied all the different options, would there not be, if there's no way to have the trial within a reasonable delay, could we recalculate? Or should we at least try to say, okay, in this case, exceptionally, we will make an exception, and this way maybe we will prevent another woman from being killed by her partner. So would you not say, Minister, that in these extreme cases, if there's no other way of doing things, we should use Section 33 to create an exemption?
But before I go to that particular remedy, I have to ask myself, because it's very serious when you invoke the notwithstanding clause. It's a decision to say we're going beyond what would be reasonably justifiable in a free and democratic society, and I don't take that lightly. There are components to this bill that address the issue in a slightly different way, and I think will actually address the problem in a way that I believe will be effective. Time will tell. But specifically, we didn't just look at the seriousness of a crime, but instead the complexity of the nature of the charge that comes before the court. Because it's often the complexity, not the seriousness of the charge, that brings the delay to a standard that is unacceptable according to the timelines in the Jordan decision. We tend to see them in cases involving organized crime, complex drug trafficking, where there's a preponderance of evidence from different sources, often of a digital nature. Increasingly, we're seeing them in sexual assault cases, which have a very complicated evidentiary regime, which we're also trying to address in this legislation. So by actually extending the permissible timeline for those complex cases, I think we can solve the problem without necessarily resorting to the reliance on the notwithstanding clause in order to address address a problem that you and I agree is a very serious problem that we must address.
Thank you, Mr. Fortin. Mr. Baver, over to you for 5 minutes.
Thank you, Chair. Attorney General, welcome back. I want to leave politics aside for a sec and just have a legal chat. I think you went to Dalhousie Law School, right? I went to Western, and I have a very vague recollection of first-year constitutional law, so I hope your memory is better than mine. Here's what I remember about how the Charter was born. Attorney General Jean Chrétien sealed the deal with the notwithstanding clause with Section 33. He agreed that in our Westminster parliamentary system, Parliament is supreme. And because Chrétien was a gentleman, he had faith that Section 33 would not be used willy-nilly and would only be used in the most extreme cases. Are you with me so far?
I'm with you, yeah.
Thank you. So to start, you would agree that you and I could come up with a scenario where the invocation of the notwithstanding clause would be appropriate.
I would like to see what that scenario is before I agree in the abstract.
But you will never. But you would not say that you would never invoke the notwithstanding clause. That there could be an extreme scenario, such as one that Chrétien contemplated, that would make you invoke the notwithstanding clause.
Well, I don't like to deal with these things in the abstract. Perhaps that's the legal training that you referred to. But if you can put an example to me, I've not seen an example where I believed it was necessary.
So let's talk about Jean Chrétien's example. Jean Chrétien's example was if the Supreme Court was to say that possession of child pornography is protected by freedom of expression, and that would lead to absurdity, an absurdity of the type that should be struck down by the Supreme Court. If they were to say that, that would be absurd, right?
Look, I feel like what you're trying to do is engage on a philosophical debate about the notwithstanding clause in the abstract. But what's important is we have an opportunity with a bill that's designed to combat intimate partner violence and exploiting kids online right now. And I feel like we're, frankly, and with respect, wasting our time on an issue that's not actually going to advance the cause of the legislation.
If I may, I'm talking about Centerville. I'm talking about the reason that prompted, and you specifically said that you've considered Centerville in Bill C-16.
Certainly.
Let's look at what happened with the co-accused, Matthew Nod, who pled guilty to possession of more than 250 videos involving the rape of children aged 5 to 10. And the Supreme Court struck down the mandatory minimum sentence for Nod and agreed to maintain, not interfere with the 9-month sentence that the court below, the first instance court, has imposed. And I suggest to you, would you not agree that striking down the mandatory minimum sentence in a situation where you have 250 videos of children being raped is the type of absurdity that Chrétien potentially had in mind?
So you and I agree on the heinous nature and unacceptable nature of the behavior that you've described, and I think we equally want to stamp that behavior out of Canadian society. Where I think we have a point of disagreement is on the correct way to address that problem. I believe the changes that we're making in this law will actually address the issue that you're dealing with, because the Supreme Court, as you will know, will strike down a provision not based on the facts before the court, but a reasonable hypothetical that could emerge under those rules. With the changes that we've made, I believe we will have protected the mandatory minimum for the heinous acts that you've described, because that person should face serious criminal penalties. And I have faith after this bill is adopted into law that we won't see that same circumstance play.
Attorney General, I think you're doing the opposite. You're undermining the mandatory minimum sentence by allowing for judicial discretion.
But the mandatory minimum doesn't apply. It's been struck down.
If I may just finish. But you have the ultimate safety valve against absurdity, which is the notwithstanding clause. And I submit to you respectfully that protecting children from rape is your most important job. And this is not just about children being raped in the videos that Nod was watching. It's about children that will be raped in the future because your government is failing to crack down on this heinous industry, which it can't do through deterrence. So why wouldn't you impose a mandatory minimum sentence for child pornography?
So in the circumstance, this is very, very important. We agree equally that that behavior needs to be addressed, including with stronger criminal penalties for people who would abuse and exploit our children, full stop. The laws that we are adopting in C-16, should this committee and the two houses of Parliament adopt them, will offer the kind of protection that you're looking for. The only difference that you and I share an opinion on is where the penalty would be intolerable to society. There should be some discretion for the court.
I have about 20 seconds.
Actually, you're out of time, Mr.
No,
Barber.
I believe I have another 20 seconds, Chair.
Well, you don't. I'm sorry.
If you would not impose the
Mr.
clause
Barber,
here, you
Mr.
will never
Barber, you're
impose
out
the
of- you're
clause.
out of time,
That's
Mr.
my
Barber.
point.
Okay.
If you would not impose
Ms.
the
Dillon, the
clause
floor
on
is
this
over.
decision,
Mr.
you will
Barber,
never
you're out of
impose
time.
it.
Ms. Dillon, over to you, please, for 5 minutes.
Thank you, Mr. Chair, and thank you to the Minister and officials for coming today to committee. You spoke briefly, Minister, about technology and how it's rapidly changing. First, there was sextortion, intimate distribution of images without consent. Now there's AI deepfakes. Technology is rapidly increasing. We are addressing what is currently the technological landscape of what happens online. But my question to you is, since technology is so rapidly changing, are there any safeguards in the legislation that would automatically address the rapidly changing technology so that the law can keep up as well?
Yeah, and let me build on my response to Mr. Chang's questioning. I think there's obvious, very direct examples, including in this legislation, in terms of how we can modernize Canada's criminal laws to better address emerging threats that have come to light as a result of shifts in technology. We've cited a few times during this committee meeting so far the prevalence of AI deepfakes and the extraordinary phenomenon of courts proactively raising the prospective need for legislative change in order to criminalize this behavior, which is arriving before them. In addition to that change, I've cited the changes to criminal harassment that will make it easier for courts to move forward with convictions if somebody's been using modern technology for GPS tracking, for example, in the context of criminal harassment. This comes up again in an increasingly digital space when it comes to the protection of children against child sexual exploitation and abuse material, including the threatened distribution of digitally held materials. But you have to remind yourself that this is part of the solution. There is no one change to the criminal law that will forever, on an evergreen basis, keep everyone safe from emerging technologies. You need to look at those other pillars of the strategy that I led with in my opening remarks. Yes, stronger laws are an essential ingredient, but we also need to give law enforcement the tools that they need, including lawful access to digitally held information, which is the subject of a bill that's going through Parliament now. We also need to make sure that law enforcement receives the training that is necessary to combat this troubling frontier of digital crime that exploits people in a sexual way. In addition to those different pieces, we also need to look at whether there are non-criminal legislative reforms that we need to put in place to ensure that we're creating safe online environments for Canadian children. You have to look across society at the range of different policies that you can advance to protect kids online. Some of them that pertain to changes to Canada's criminal law are included in this bill, but that's only part of the job. So this is not a mission accomplished meeting. This is a step in the right direction that is so sorely needed and needed as soon as possible.
Thank you, Minister. And you spoke also about coercive control. You've met with experts and professionals in the field. You spoke about behaviors. Have they explained to you a little bit what kind of behaviors would fall under this category?
Sorry, in which category?
Under coercive control.
Certainly. So we're dealing with the kinds of circumstances that would involve violence in the home, including violence against pets in the home, which we know is predictive of violence against people who live in the home. We are dealing with sexual coercion. We're dealing with a range of different behaviors, but perhaps if I could encapsulate them simply, these are behaviors that would cause a person to reasonably fear for their physical or psychological safety. This is not someone who has a difference of opinion. This is not somebody who asks where a person went for coffee that day out of interest on how their day was going. This is a pattern of behaviors that we know are predictive towards violence, often fatal violence in a relationship. It's very serious, and we need to take action. We have made the decision to have a delayed coming into force to give time for the system to become ready to deal with these new challenges in response to very real feedback. We heard about the potential weaponization of coercive control against the perpetrator of an abusive relationship. But by enumerating sets of behaviors that would reasonably cause a person to fear for their safety, I think we've hit the right mark as long as we combine that with training at a systems level to ensure that the courts have the ability and the law enforcement has the ability to move forward with this offense in the way it was intended.
Thank you. And often we hear victims saying how difficult it is to navigate the justice system. How will this legislation help provide them protection and a better way to go through this system while they are testifying or in any other event?
So there's a number of different ways, some of which directly impact a victim who's going through the system of a particular crime. Changes in terms of the standard for criminal harassment would be one example that I've discussed earlier. Dealing with new laws that currently courts don't consider, dealing with delays in the system where we've seen cases thrown out again because too much time has passed, not because the charges weren't made out. But in addition to these changes that will fundamentally shift the experience of the victim going through, which may lead to a conviction for the perpetrator. We're also including reforms to the Victim's Bill of Rights that makes clear there are certain entitlements to the victim in terms of the process that they should be able to take part in. The number of changes include putting clarity around their right to testimonial aids, their right to receive info about the process. So it will be shared proactively, the ability to make complaints to the victim's ombudsperson. There's a number of different reforms included when it comes to the Victim's Bill of Rights, but we've tried to go through to make sure that victims understand they have a role to play in the process, they have a right to have their voice heard, and they have a right to certain procedural aspects that make it easier to have their voice heard. So whether it's on the process side or substantive changes, we do expect these changes will manifest in a way that will markedly improve a victim's experience going through the court system.
Thank you, Minister.
Thank you, Ms. Dillon. Mr. Fortin, over to you for 2.5 minutes.
Merci, Monsieur le Président.
Thank you, Chair. Minister, on the question of inciting minors to commit a crime, this is a subject that really concerns the Bloc Québécois. I had worked on a bill on the subject. I think our approach was a little bit more, shall I say, robust than what you're proposing in C-16. I believe that that's actually one of the most serious crimes that one can commit, inciting a minor to commit a crime in one's place. It's cowardly, it's criminal, and it creates, or at least it risks creating a new type of criminal that will operate in a particular fashion. I think that's totally unacceptable. It's a major problem that we need to tackle. I had thought of saying, well, if you try to incite a minor to rob a bank, for example, provided there's enough evidence, you would actually receive double the sentence than you would have received if you had committed the crime yourself. That seems to me a way that might effectively really eradicate that problem. You're proposing 5-year sentences, I believe, for cases like that. Obviously, it's better than nothing. I'm not saying it's not a good idea. But again, I just found it a little bit timid. So I'm wondering if you would go further in order to crack down on this scourge, because it's often adults, often members of criminal organizations who incite minors to behave in this way.
Okay, merci.
Thank you. Before starting, I just want to really thank you. I know this is your idea. When we have discussions on the issues that you're working on, you always bring these issues to my attention. You've talked about adults inciting minors to violence, and that's the reason that it's in this bill, so thank you. When I was considering the appropriate consequences, I looked at similar offenses that currently exist. So currently we have an offense of recruitment of people to criminal organizations. The sentence for that offense is 5 years. So if the committee's perspective is that we should adopt a different way of tackling the problem, I'm okay with that. You can propose amendments. You can work with the other members of the committee. And if my department is able to clarify, why we should choose one strategy over another, that would be possible. We would certainly consider those amendments. Thank you.
Mr. Lawton, over to you for 5 minutes.
Thank you, Minister, for being here. When Mr. Baber was asking you about the notwithstanding clause, you said something I felt was quite interesting, that you didn't think it was productive to engage in hypotheticals. Yet the Senville decision was the Supreme Court doing that very thing. It was the Supreme Court inventing a case that was not before it and using that to strike down mandatory minimum sentences that applied to the very heinous people that were at issue in that case, and that is Mr. Senville and Mr. Nod. So I'll begin there. Do you think it is reasonable for courts, for unelected judges, to use reasonable hypotheticals to override laws that parliamentarians have put in place?
I do think courts, and it's interesting you should say, use my desire not to discuss things in the abstract. Well, the courts use the hypothetical. I think it's actually important that courts use those reasonable hypotheticals that can and do, in fact, exist in reality. When they're assessing the application of criminal law that could result in the person's incarceration, they need to consider whether we drafted good laws. When we're drafting good laws, we need to make sure that we're trying to address real-world problems, not things that we think may exist. And I think the way that each body, as a function of the decisions we take as a government and a legal system, improves the quality over time of the decisions that are finally rendered and baked into our laws.
But as the dissent in Senville says, a reasonable hypothetical has to first and foremost be reasonable. The two cases that went up to the Supreme Court involved two individual men that had between them thousands of images and videos of child sexual abuse and exploitation material, children as young as, I think, 3 and 4 years old being subjected to absolutely heinous acts. The scenario the Supreme Court invented did not exist in any of the law before. It was not at issue, and pretty much every legal expert I've spoken to about this has said likely would never end up in that situation because of safeguards in place that would have prevented most likely a charge from even being laid under child sexual exploitation and abuse material. So my question is, why are we catering to this extreme case that does not exist in law, and in doing so, removing a very real and I would say very necessary mandatory minimum that is there to ensure that actual heinous predators are given a minimum, which I think is far too low, of 1 year?
So there's a couple of things that I'll offer in response. First, on the reasonableness of the hypothetical. First, let me say, we agree on how heinous the behavior was on the underlying facts that went to the Supreme Court. And I think every one of our colleagues, regardless of party, feels the same way, that we need strong laws to address such egregious behavior. The reasonable hypothetical that they cited involving somebody who's aged out of a teenage relationship effectively is the kind of thing that exists in our society. And since that case has come up, I've actually had a few people come to me in a coaching, cadet program, teaching environment where they say, these things do come up, and we hope that you do crack down on the bad actors, but the 18-year-old who innocently received a picture probably isn't who you're thinking of when you think about child sexual exploitation and abuse material. So from my perspective, the use of that reasonable hypothetical is important to ensure that our laws capture appropriately the kind of egregious conduct that was the subject of the offenses committed in that decision.
Do you think some judges are too lenient?
Look, I would agree or disagree with an individual decision on a given basis.
I'll ask it in a more clear way, Minister. Do you believe that mandatory minimums are an important tool to prevent decisions that are too lenient for the facts at hand?
I have a different view as to why they're important. I think you want some certainty that certain crimes will be met with serious penalties, and I think that you have the opportunity to demonstrate as a society that certain behaviors will not be tolerated. So I support the reintroduction of these mandatory minimums that protect those in the books.
Because in the Senville case, you had judges that were actually ignoring existing mandatory minimums, even without a so-called safety valve. The Investigative Journalism Bureau analyzed 100 cases between 2020 and 2025 and found that one in 3 sentences for child sexual abuse material possession had not adhered to the previous sentencing minimum. So why is the existing minimum, even prior to the Supreme Court weighing in, not keeping these offenders behind bars?
I can't speak to what might be in the head of an individual judge for an individual case. The reasons may have varied between those cases. Suffice it to say, my view is that the mandatory minimum should be upheld, with the exception of these cases where it would be grossly disproportionate. So one of the changes that's actually being proposed in this legislation will help address the problem that you've raised by saying if you're going to deviate, you actually have to explain why. If you offer reasons as to why it would be grossly disproportionate, why society would be outraged, etc., then I could understand why you might see someone moving away. So I actually think in an exercise of transparency, this bill is not only going to restore the mandatory minimums, but give more clarity on the kinds of cases that you've just raised with me now.
Thank you, Mr. Lawton. Last round goes to Mr. Housefather for 5 minutes.
Thank you. Thank you, Mr. Chair. Thank you, Sean. Much appreciated that you're before the committee. I have a few questions, but before I get to my questions, I just wanted to enter into the issue of the notwithstanding clause because it sounds like our Conservative colleagues have been using their question time to argue that the notwithstanding clause should have been used here. Minister, the notwithstanding clause has never been used by the federal parliament, correct?
Yes.
And Jean Chrétien was the Prime Minister for 10 years during the course of time that the notwithstanding clause was part of the Charter of Rights. He never used the notwithstanding clause, correct?
And remains proud of that.
And in my recollection, there were cases during Jean Chrétien's time as Prime Minister, for example, Marshall on fishing rights, the same-sex marriage case, that Chrétien himself had said that he had reservations about, correct?
Certainly.
But yet he still managed to not use it, because using the notwithstanding clause is essentially saying that we have a protected right under the Charter, and we're, and we're going to say we're using it because we're not going to limit the right in a way that is reasonable in a free and democratic society. And by using the notwithstanding clause, we're essentially acknowledging that, correct?
That's right. You've articulated the limit that I think we should do everything we can to live within.
And there are alternatives to using the notwithstanding clause to get around a case, for example, like Senneville, correct? For example, rewriting the law to address the concerns expressed by the majority in the court decision, whether we agree with it or not, as you have done in this case in C-16, correct?
And more specifically, not only to address the concerns, but to achieve the same or greater level of public safety than exists given the laws that we have today, particularly in the context of mandatory minimums that are written in the code but have been struck down.
Exactly. Like if we go to what exactly you have proposed in Bill C-16, you're essentially restoring the mandatory minimums, but giving the court the flexibility in a case where you would have one of these reasonable hypotheticals where it would be brought before the court because nobody can be sure, no matter how long they were a prosecutor, that no prosecutor would ever bring such a case. You're ensuring that the court then will likely agree that the way the law is now drafted is reasonable. It's a reasonable limit on a freedom that is subject to the notwithstanding clause because of the fact that the court has the discretion in that case, this rare case, to impose a lesser sentence, correct?
And I expect as a result of these changes, in fact, far more mandatory minimums will be upheld in the real world as a result of these changes.
I would agree with you. Can I ask you, Minister, one of the really important things that I don't think we've touched on is how much consultation you did to get us to this bill, because consultation is the key to making sure that we have legislation that multiple stakeholders and hopefully a consensus in Parliament will agree to. Could you just talk about the lengthy process of consultation you, your parliamentary secretary, and the department did with respect to this bill?
Look, certainly, and at risk of running out of time here, Mr. Chair, I think we should all acknowledge that we don't make good decisions if elected officials sit amongst one another behind closed doors and come up with an idea. There are people who are experts who have dedicated their lives, their careers, or are willing to loan their expertise earned through lived experience to inform what changes cause problems in people's lives and what solutions will avoid those problems for people going forward. We spoke with law enforcement, with victims advocates, with people who have been victimized by crimes, including sexual crimes, with people who have lost their family members to violence, and we want to respond to that very real-world phenomenon that too many people are being hurt, too many people are being abused, too many people are being killed. We want to breathe their voices into the laws that we adopt so we can offer protections for people who are living through circumstances that they continue to live with the consequences of every single day.
Mr. Chair, do I have any time left?
You have 1 minute.
Could I just then enter, Mr. Minister, could you just talk a little bit about how you decided to move towards the principles illustrated in the law to deal with Jordan? Like, what consultations did you do? Because I heard Mr. Fortin's comments, and I think it's important to talk about how much you consulted when you came up with the principles of what days would be reduced and so forth. Could you just sort of talk about who you talked to?
Look, very quickly, lawyers with experience in prosecution and defense, those responsible for the courts, law enforcement who are frustrated with cases that they have poured themselves into only to have the result be a stay of proceedings without it coming to its natural conclusion, and importantly, victims who have actually lived through this experience, people who have seen a crime committed against them go unpunished as a result of delays, not as a result of an accused person defeating the charges and receiving a verdict of not guilty. We tried to understand the experience, and I'm sure you as an MP, like I have probably seen this injustice play out over the course of your career in politics. When you sit down with somebody who tells you that they were assaulted sexually and that the perpetrator lives in their community, was charged but let go because the clock ran out, I can tell you that doesn't feel like justice to the victim. It doesn't feel like justice to me, and we need to take action.
Agreed. Thank you so much.
Thank you, Mr. Housefather. Minister, thanks very much for being here today, and thank you for your time. We'll suspend for a few moments, and then we'll get to the second round.
Okay, so we're going to switch over to the Public Accounts Committee for the second hour here. The Auditor General is there, or was there, while we were watching this, so we're just going to go watch the Auditor General for an hour. She has some new spring reports. And let me just switch over.
Of the 2026 spring reports of the Auditor General of Canada.
The Office of the Auditor General for our first hour. Karen Hogan, Auditor General of Canada, thank you for coming in today and being ready to answer questions on the reports. Andrew Hayes, the Deputy Auditor General. Nathalie Chartrand, Principal, nice to see you. Sami Hamouche, nice to see you again. Jean Goulet, bonjour Jean Goulet, bonjour, it's nice to see you as well. Normand Lantier, bonjour. And Gabrielle Lombardi, Principal. And many were principals before as I was saying hello as well, so pardon me. In fact, yes, the 5 of you are principals. All right. Ms. Hogan, you have the floor for up to 5 minutes, but if you decide your introduction needs to be longer, you have the time, or if it's short, that works as well. We have lots of questions for you. The floor is yours.
Thank you. It'll be a little bit more than 5, but I'll try to speak fast.
You go right ahead and don't rush. Take your time.
D'accord. Bonjour. Merci, Monsieur le Président, et je vous remercie.
Thank you, and thank you, Chair, for giving us this opportunity to testify before the committee today.
Traditional unceded territory of the Algonquin Anishinaabe people. I am here today to discuss the findings of 3 audits that were tabled this morning in Parliament. These audits examined how well government organizations are managing important federal initiatives, the replacement of the government's pay system, reforms to the International Student Program, and the RCMP's efforts to recruit police officers. In addition, as is our usual practice, we have also provided Parliament with copies of our special examinations of the Atlantic Pilotage Authority and Via Rail, which were made public since our last tabling. I will begin with our audit of the federal government's project to modernize its pay system. Nous avons conclu que le secrétariat du Conseil du
We concluded that the Treasury Board Secretariat and Public Services Canada manage the pay modernization project to ensure that federal public service will have accurate, timely pay. Some risks were noted at the beginning of the project. The Secretariat and the Department given that it's at the beginning, they have the opportunity to act to correct them. I'd like to start by three elements. First of all, progress made to simplify pay rules was limited. This will require a customization of the Dayforce application costing $4 million per year. Moreover, there's a 133,000 backlog of pay requests, and transferring them could introduce errors into the new system. Finally, the timeline has been shortened by 3 years, shortening at the same time the possibility to eliminate the backlog and to get the project done on time. The department will have to make decisions quickly as this project moves forward.
And Citizenship Canada reduced the number of new study permits issued, but fell short in other key areas. In 2024, the department issued just under 150,000 permits, well below the forecast of 350,000. Some provinces, particularly those with smaller populations, were disproportionately affected. For example, Newfoundland and Labrador and Saskatchewan were both expected to see an increase of 10% in approved study permits compared to 2023, but instead experienced a decrease of at least 59%. While the department introduced a tool to verify acceptance letters from learning institutions, it did not effectively investigate or follow up on high-risk cases. Over 153,000 potential cases of non-compliance with study permits were identified, but the department investigated only a small number. It also did not pursue 800 cases involving fraud discovered after permits were approved. In most of these cases, individuals went on to apply for other immigration permits while in Canada, and more than half of them have since been approved. Overall, the department needs to act on the information it has to address integrity concerns in the program. En ce qui concerne le recrutement de la Gendarmerie royale du Canada.
With regard to RCMP recruitment, the audit concluded that the RCMP did not recruit enough police members to respond to its needs. The recruitment target set by the RCMP was lower than the needs and was not met. Major delays in application processing slowed down recruiting. The RCMP did not respect processing time for 97% of applications. In September 2025, there were 3,400 too few police officers. This trend was generalized across Canada, especially in contract and Indigenous policing services. The number of vacancies was critical in 9 out of 11 provinces and territories served by the RCMP. A flexible recruiting system drew thousands of candidates, but there were nonetheless shortfalls in many regions. The RCMP should better define its need for new recruits and set targets to meet them.
Of careful planning and timely action to address risks. Without these elements, there can be delays and unintended impacts that stand in the way of positive outcomes for Canada. Mr. Chair, this concludes my opening remarks. We'd be pleased to answer any questions the committee may have. Thank you.
Thank you very much. We have time for 2 full rounds today. The first one will consist of 3 members, 6 minutes each, and then another round of 5 minutes with various times. Ms. Kuzi, and that will take us to about the top of the hour, noon, or just a few minutes after. I know you've got a busy day, Auditor, so we will endeavour to move this along quickly. Ms. Kuzi, you have the floor for 6 minutes, please.
Thank you, Chair. And again, thank you very much, Auditor General, for your excellent work. The system that you are referring to in the report today costs Canadians a minimum of $4.2 billion. Yet your key finding indicates the need to simplify and standardize pay rules before introducing a new system was a core lesson learned from the transition to the Phoenix pay system. Yet it's concerning to you, a decade later, there is little progress made to simplify these rules, and that customizing the new pay system is costing taxpayers an additional $4 million a year. How could this have been avoided?
Well, I think that's a great question to go ask Treasury Board Secretariat and Public Service and Procurement Canada. When we came in here, we were just trying to see if they had acted on lessons learned. And one of those key areas is simplifying pay rules and standardizing pay processes. We did see one simplification agreed to with unions. But there's a lot of work left to be done. As a result, however, the mitigation measure is to customize Dayforce so that they can avoid payers in the future. I think there needs to be an effort put on by all parties involved to make sure that everyone is being paid accurately and on time. How they go about doing that, I'll leave to the central agencies and the unions. But it's clear that if you don't simplify, you need to at least customize to make sure pay is accurate.
Yet despite all of these customizations for $4 million a year, manual workarounds are still required. Why would this be, despite $4 million a year for customizations, that manual workarounds would still be necessitated?
I think the Dayforce system is not just about replacing the Phoenix pay system. So it's not just the box that handles pay. It's also replacing HR management systems. There are about 30 different ones across the departments that are serviced by Miramichi Pay Center. So this is a more end-to-end from onboarding to paying. So it isn't just about pay. So there'll always be processes before you get to the pay system. And it's about making sure that all of them have been standardized as well. And we always saw some progress on standardization. No department is adopting that until they get onto Dayforce. So it is too soon to know the impact it will have on treating pay.
In fiscal year 2024-2025, 29% of normal and acting pay payments had errors within them. Do you think 29% is an acceptable rate for a pay system and for this government?
I think every employee expects to be paid accurately and on time. The number that you raise is the figure that we identified during our financial audit work for the Government of Canada. We've seen over years, because we've been tracking that every year, that it ebbs and flows. And that's why it's important in my mind to make sure that you have simplified the pay rules and standardized processes, cleared up all of these pay errors before you move a department onto the new Dayforce system. Because if you bring a pay over with errors, doesn't matter what system is processing it, there will be errors again.
Your report indicates that in 2023, Public Services and Procurement Canada set a target to eliminate all pay transactions that were 1 year or older by March 2026. Since then, the department's internal reports through September 2025 indicated it would not meet the target. How can Canadians have confidence in a government that once again can't even meet their own targets?
One of the concerns and risks that we flagged with this project. It is clear that progress is being made on the backlog. We're seeing it decline, but what's concerning is the age of it. More than 50% of what's in there is more than 2 years old. At least 16,000 pay action requests are more than 6 years old. And it's those older ones that in my mind will be more complex to solve. The longer you go out, that will take more time, and that's why we flagged a very big risk of shortening the timelines. And I would expect that Treasury Board Secretariat and Public Service and Procurement Canada are going to adjust their way forward because you need time to make sure that pay is accurate before you move it into the new system.
Was there any evidence at all that the government is considering the future implications of CER and the additional pressure that this will put on the system?
Well, I think that's one of the elements that I would call an emerging risk, right? So there's risks right now that are known, and then there's obviously an emerging risk that comprehensive expenditure review and early retirement incentives will all have pressure on pay and clearing out the backlog. So this is one of those key elements that I think needs to be factored in right now that will require a lot of diligence. It's not just identified risks, but also emerging risks that need to be monitored and mitigated throughout a big project like this.
In the report, you mentioned the corporation Russ Gilroy that was retained for work on the Phoenix project. Do you have any information as to how that company was retained?
I unfortunately do not know how Goss Gilroy was retained, but I did look at their report, and many of their findings and concerns or recommendations echo some from my office back in 2018 and some that we're flagging right now. I think whenever you have a big project like this, there's a risk that you'll prioritize timelines over functionality and costs, and it's important to make sure that people are paid accurately, and that's why a key step is to clear out all of this backlog before transition happens, and that's a risk I hope the government will monitor closely and adjust as needed so that they can meet the accelerated time frame.
Thank you, merci beaucoup. Thank you, Ms. Kuzi. Ms. Yip, you have the floor for 6 minutes, please.
Thank you. And thank you, Ms. Hogan, and to your entire team for the good and productive work of these spring reports. Your work is always very important for us to improve. Thank you. Okay. So I'm going to be asking you some questions on the RCMP report. Why did the RCMP fail to recruit enough police officers to meet operational needs?
Well, I think the biggest reason would be the slowness at which they process applications that they received. It isn't a shortage of interest in the RCMP, but there is only 6% of the applications received over the 30 months of our audit that made it to being an offer of going to basic training. So there are a lot of applications, about 40% of them, that individuals either withdrew their application or stopped communicating with the RCMP, likely because of the length of time. The RCMP has a service standard that says an application should be processed in 224 days, and we found that on average it was taking 330 days. So really speeding that up will need to be an important step in order to increase the number of recruits that make it through. I think the last item I would raise about this is starting with knowing your needs is essential. And right now, the needs or the targets they were setting for recruitment were set based on how many people they could train. And that was falling well short of their actual needs. We believe they need at least 3,400 police officers. If they think about where their vacancies are and attrition, you have to factor all that in. And so they're setting a target just too low for what they need right now.
Was there anything that you felt they could do to speed up the application process?
Oh, it's a great question. Actually, a good conversation I had with the commissioner myself around how do you adjust this. We identified a couple of areas that we thought might have been contributing to this. One being that there is a recruiting analyst that sort of picks up a file and moves it through the 7 steps. Most of those positions, or half of those positions, are sitting vacant right now. So that will be a contributing factor. But we also talked about how many of the steps are done one after the other for the most part. So there's an opportunity to do them together sequentially, but also, or concurrently, I should say, but also to do them in a different order, right? Identify where most are being eliminated from the process and see if you can move that up. For example, the medical or physical exams and security clearances. So if those can be moved up, that could probably speed up the process. So I think there's lots of opportunities, and the commissioner has already, I think, spoken publicly about how he's hired a third party to help them work on this, and their goal is to reduce that timeline to 6 months. If they do that, as we mentioned in our report, make sure that you change your service standard by step so you can measure whether your efforts are being successful or not.
6 months is still a long time.
Well, I think if you're looking for a job, waiting any amount of time is a long time, but 330 days is very long. So 6 months would be an improvement for sure.
That is true. Why was the recruiting officer the one that reviews the 7 steps? Why were so many of that particular position vacant?
I'm not sure that I know the answer to that. I think that would be a good question for the RCMP. But what we did see is that there is a fall-on effect from not having enough frontline police officers. So we really focused in on those who service Canadians on a day-to-day. But many of those experienced officers move into other areas of the RCMP, whether it be federal policing, special services, or even their internal services. And so when you have a high vacancy rate in one, you tend to have a high vacancy rate all over the organization. So I think that's something they need to prioritize where their resources are used.
In your report, it mentions that analysis of the RCMP's data shows that the shortage of police officers has worsened in the last 2 years. Why is that?
Well, I think I would highlight the 2 elements that I raised already. One being how long it takes to process an application. The majority of frontline police officers come through the contract and Indigenous policing business line. And they changed their focus to really look at the vacancies there. But many of those officers, once they're experienced, move to other areas. And so when you don't have a clear picture of what your needs are across the entire organization, you're really only targeting to meet the needs of one business line, you're falling short. So I think there's many elements that have contributed, but the RCMP tried out measures to try and increase that. They put in place a flexible posting plan. And while that posting plan really attracted thousands more applications than they expected, it had an unintended consequence of seeing new police officers pick the province or territory they wanted to work in, so the coasts of the country, and then you saw vacancies in the rest of the country increase. They've since decided to repeal that, so draw it back. But I think this is why it's important to make sure that you measure whether all of your efforts are having the intended impact that you wanted.
Thank you. That is your time. Monsieur, suivant, c'est Monsieur Lemire, s'il vous plaît, pour 6 minutes.
Monsieur Lemire, you have 6 minutes. Thank you, Chair, and thank you, Madam Auditor General, for your very rigorous reports, and thanks once again to the entire team. A little background, first of all, to talk about Dayforce. Phoenix was put into place in 2016. It was assessed to be over $200 million in cost, and now we're close to $5 billion, and only $2 billion went to problem solving with Phoenix, that is. That's taxpayer money. In 2019, we knew that Phoenix had problems and was not the software of the future. A new contract was signed in 2019 with Dayforce at $57 million. Last June, Minister Joel Lightbound announced a $350 million contract with Dayforce, and there would be a possibility of renewal for 20 years. In your report, the costs are already assessed at $560 million, an additional $200 million, that is. than what was expected, and the entire project will cost $4.2 billion. Is that the reading that we should have of the federal government's pay systems? You gave a lot of numbers. I think it's important to remember that the current costs, over $500 million, are not just the cost of the contract, but the cost of internal, that is, government services in this contract. Obviously, when there's a preliminary estimate, one expects that the costs will arise because of more detail that comes as the contract continues. The government needs to look closely at the costs with the third party and also what Phoenix currently costs them and how much pay processing will cost with Dayforce. This is what should be determined whether the costs have gone down with a new pay system. Now, we're talking about a $4.2 billion estimate. Does that include supplementary funding beyond the $565 million? The cost of the project, currently estimated at $4.2 billion, does include spending that has already occurred. Spending by the departments, that is. It's nonetheless a rough estimate and does not include, in my opinion, a very, very important expense. That is the cost of transitioning to this new system for all departments and agencies. Currently, we're just looking at the cost of the system and the central agencies that are included in that amount. We know that to bring 49 departments into that system, we still do not have the rough estimate of the transition costs, and we're already at $4.2 billion. Currently, 49 departments are handled by the Miramichi Pay Center, but there are also other departments and agencies under Phoenix that will transition to Dayforce. So in all, there's some 100 organizations that will have to make this transition. On page 14, paragraph 31 in your report, there is a detailed estimate of the costs to be submitted to the Treasury Board Secretariat. These preliminary costs, the projected costs, budgeted to the tune of $2 billion extra, you're saying that already it will cost more. There will be more costs than for what has already been spent. You're talking about the cost of the project versus the funding by the Treasury Board Secretariat. There have been funding tranches, and these. The figures have to constantly be updated so that other tranches of money are given. The $4.2 billion does not include the cost of all the departments integrating into Dayforce. We recommend that there be a full understanding of this cost of transition to Dayforce, not just for the cost of the central agencies. So there is a tremendous challenge for the government to assess the cost. Every year the costs go up. There are fewer and fewer operational competencies within the government. Have you assessed the amount per operation and how it contributes to the overall cost for the government? No, we're still at the beginning of the project. Currently, we wanted to see if we could find recommendations to improve the project and prevent another Phoenix from occurring. It's still too early to assess all the contracts, the third-party contracts that is, but one of the recommendations we made is that the government conduct an assessment right now to figure out how much their pay system costs so it can compare to the new system. Because, of course, the idea is to reduce the cost of pay processing. The target needs to be set. The information needs to be found already. You've said it's too early, but I think that for Minister McKinnon, it will be too early and there will be cost overruns.
Times. Monsieur Deltel, s'il vous plaît, pour 5 minutes.
Merci beaucoup, Monsieur le Président, collègues.
You have 5 minutes. Hello. Welcome to the committee. Once again, excellent reports. Thank you, Ms. Hogan, and all your team. You've raised concerns, among other, the Dayforce program that reminds us, sadly, of the Phoenix tragedy. And it is a tragedy because we're talking about hundreds of thousands of Canadian families who have suffered and gone through tragedies because of Phoenix tragedies. In 2015, before it was implemented, we stopped its production so that it would go well, and yet the green light was given, and we know that it became a real tragedy. Now, when it comes to Dayforce, Dayforce aims to have simplified pay rules. The problem, Ms. Hogan says, is that you said 10 years later, the work done to simplify the rules is fairly limited, and ultimately the simplification will cost more. What do you mean by that?
Le secrétaire du Conseil du Trésor, ils ont une...
This is a question that should be asked of the Treasury Board Secretariat. There is an agreement with the union to negotiate and agree on simplified pay rules. Some simplification has been done since Phoenix, but I believe that all parties believe that paying public servants accurately and in a timely manner is the goal. When there's a lack of simplification, there is nonetheless a control of attenuation management, a certain mitigation measures. In 2024 and 2025, 29% of pays were wrong. And for federal public workers, that means 1 out of every 3 paychecks was wrong. How can that be? Well, since the Phoenix transition, my office has been checking the pay services every single year. And in 2025, we remarked that 29% of public service workers have pay errors. The source of the errors is really data entered incorrectly or too late. That's why it's so important to understand that this is a shared task. Pay processing involves all the agencies and departments working with the central agencies. That's why it's so important to get through this backlog of pay problems. When we transition, we need to the new pay system, we need to be sure that this backlog is done. There will still be errors, of course. There will always be pay errors. But I think the risk now is that the central agency is that there are risks that the central agencies have to manage and mitigate. And for anyone working in the federal system, including your team and you yourself, should we be more worried? Currently, most public service workers are paid accurately. But we decided to carry out this audit because we don't want there to be a repeat of the shortcomings and errors that we saw with Phoenix. We raised red flags for risks that must be better managed. We'll be doing follow-up, very close follow-up, to support the government in its payment of its employees in a timely and accurate manner. I'd like to talk to you about another report regarding the international students. We understood that much information has been forgotten. Is it because of the challenges posed by immigration and border services or permits that there are people working in silos, government services done in silo? You've raised some very important points. Better collaboration with provinces and post-secondary institutions to manage the assignment of permits, as well as better information sharing between the Minister of Immigration and the Minister of Border Services would help. There are concerns that are raised during application processing, and it would be interesting to see better collaboration within the government and with the provinces, territories, and teaching institutions.
Mr. Dirksen, please, for 5 minutes.
Great. Thank you very much, Mr. Chair, and great job on these reports. Thanks so much for your hard work on them. I am going to continue talking about the pay modernization. There's some indications that departments are on the right track, but you've certainly articulated concerns you have over the shortened timeline, for example, and also balancing priorities of scheduling with pay processes. In your report, I understand that the number of pay transactions older than a year has been reduced by 50% over the last 2 years, but you've expressed concerns with the pace being adequate enough to address the remaining backlog. So I'll ask, do you see opportunities to increase pace without sacrificing process integrity?
Well, I mean, that's a tough question because I think the backlog has gone down when you look at it year over year, and we've given you a great chart in the report to look at it. But concerning is that more than 50% of what remains is more than 2 years old, and about 16,000 pay transactions are more than 6 years old. Those will take longer to treat and resolve than something that just came in the last 6 months or so. So I am concerned that those older ones don't seem to be clearing up, and that will take some time, and that's why shortening the time frame is a concern. We did see in the audit where they prioritized the departments that are going to be in the first wave of adopting Dayforce, and that's a good practice. They still have a lot of work, however, to do. They still have pay transactions to clear, and recognizing that every single day there will be more that get added, right? Pay is a very evolving item, and if you don't tackle them quickly, they do become things that sit around that take a really long time and may be complex. Many of those individuals may no longer work for the public service, so it's going to be really difficult, I think, to resolve some of those older things, and it'll be a right balance. It'll probably take some resources, but it will be about prioritizing, what you treat first.
Okay, yeah, so one of the issues that I believe you identified as having contributed to the inefficiencies and the backlogs in the old system is the quality of data. So I understand that the departments, PSPC and TBS, have taken some steps to improve quality of data and the data management. Can you provide us your evaluation on if those improvements on data management are going to be adequate?
So I'm not sure that I looked at all of them, but I think what I would point to is about standardizations of processes. So you do need to have all the departments and agencies who are part of this, right? Pay is not just a black box that gives you your paycheck. It is a whole from onboarding and any change in your life to your pay. So it does need departments and agencies to be involved. So that whole HR to pay process is important. They've identified about 200 processes that could be standardized, and they've, for example, what would go in a letter of offer, making sure every letter of offer has the same things that are needed within the pay system so that you're not missing it. But departments only need to adopt those standardized processes when they shift. So I think there's an opportunity to look at the timing of that, and is there merit in maybe starting to standardize things now so that not everyone is rushing, right? These are all elements that I would expect are considered now that the decision was made to shorten the timeline to transition. And that's why we're so early on that we could at least say these are concerns and make sure you think about them as you move forward.
Yeah, you touch on something important there about the, one hand talking to the other within departments. And that's a concept that's come up a few times today about the siloing and the isolation that some departments work within. So based on the necessity of integration between the central agencies and departments and the siloing of estimated costs and the way the federal government, sometimes it just works that way, right? For better or worse. Would you say this is a result of kind of a systemic a culture, like a culture of systems? Have you seen any programs that have successfully unsiloed and taken a broader canvas of potential costs and impacts?
Oh, you're going to make Andrew and I think about that. If we've seen something that has successfully unsiloed, I think this is definitely an opportunity to try and do different, which is why some of our recommendations have been made to think about this more globally. I think what I would encourage every public servant to do when they work on a project is not to think about my department, my deputy head, who am I accountable for, my budget, but to take the look of a Canadian. A Canadian looks at the federal government and just sees one organization, not the many little silos that we function in. So if we started to think that way, then maybe we would, plan differently and cost differently. And that's why some of the recommendations we issued were meant to really challenge thinking the old way so that we don't repeat Phoenix.
And that is your time, I'm afraid. Suivant encore une fois, c'est M. Lemire pour 2 minutes 30 secondes, s'il vous plaît.
Mr. Lemire, you have 2 minutes 30 seconds. Thank you, Chair. Ms. Hogan, I'd like to understand patterns in the federal government's IT services. This week there was an article in La Presse discussing Currum. It states that in 5 or 6 years, when the program is done, there will still not be a proper understanding of the cost. With regard to Arrive Can, 4 people received $330 million. We understand that there was some abuse or misconduct, perhaps, with regard to the whole process. IT projects always have cost overruns. Ottawa accepts this and does not know how much Currum will cost. Do you agree that with all IT projects, there is a problem, that the initial cost estimates are not well done, and that we can therefore expect that these projects, that Dayforce rather, will cost way more than the $4.2 billion currently estimated? It's not only with IT projects that we see major shortcomings in the rough initial estimates. Yes, of course, in IT projects as well, but I would point out, or I would say rather, that sometimes preliminary estimates are simply preliminary. They're set up to rapidly receive funding and better determine the costs after. However, as we've noted here with Dayforce, there are major costs that aren't necessarily included in a rough estimate, and there need to be adjustments. Sometimes a lack of understanding of the complexity of the service or tool requested is the problem, and there may also be changing requirements over time. Arrive Can was one example of this. Requirements at the borders changed during the pandemic, and many things can contribute to complexity, but there's still that need to have an overall idea at the beginning that is often identified as lacking in projects in general. Thank you. Thank you, Mr. Lemire.
I think we're going to split the time here. Mr. Couric, would you like to kick it off, or is it Mr. Stevenson? Mr. Couric, you have the. Would you like me to interrupt halfway through, or are you going to hand over
if you
to your
could,
colleague?
I have my timer on, but if you could interrupt,
I'll
that'd be great.
notify you when you're halfway through your time.
Thank you, everybody, for attending today, and thank you for your very detailed reports. I'll be starting on the International Student Program reforms. So between 2023 and 2024, we had 153,000 students that were identified as potentially non-compliant. Now, in your report, you stated because of budget issues, only 2,000 were able to be looked at annually. So a total of 4,000 and change cases were looked at. So is it to my understanding that roughly around 49,000 potentially non-compliant cases were not looked at?
Yes, that's the figures that the department gave us, is they only had funding to look at a little over 4,000, which means the others were not investigated. But I think what's concerning for me is when they did investigate the 4,000 is about 40% of them were closed. Those cases were closed, but it was because the students stopped communicating with the immigration department. And I would have expected that they would have taken that all the way to the end to determine whether or not a student was meeting the terms of the permit. Remember that these are just students being flagged as potentially non-compliant. You need to give them an opportunity to demonstrate that they are studying full-time.
Okay, thank you. Also here, so your audit examined nearly 550,000 individuals whose study permits expired in 2024. You identified, or there was identified, 39,500 individuals who could no longer be in Canada because they did not have immigration status. Where was this 39,000? How did we get that number?
So I think this is one of the examples that I cited about immigration department not acting on the information that it had. Study permits have an expiry date, and they were not putting together a list of students who had expired permits to assess what was happening. So our audit team worked with them to determine how many students had expired permits, and then to find out whether...
Sorry, just to make that clear. So it was your team who compiled that list, not immigration. So you found the error, and your team, on top of doing the audit list, or this audit, actually assisted them in helping and put together this list.
Correct. We worked with them closely to go through their database and identify all the students with expired permits. The next step was then to assess whether or not they had applied for any other immigration permit, and that's where we ended up with our list of a little over 39,000 students. We then took that list and went to the Canada Border Services Agency and asked them to confirm if individuals had left the country. The result is about 40% had. Now it's up to the Immigration Department and Border Services to decide what to do with the remaining individuals and take action as they deem necessary.
Okay. Thank you very much. Thank you. Mr. Stevenson, you have just over 2 minutes. You have the floor.
Thank you. I believe that there's a bit of a romantic affiliation or feeling towards our RCMP and the general public, but I don't think they necessarily agree with all of our bureaucratic problems that we might have going forward. I see at the back of your report, there's a lot of the recommendations, and then there's responses from the RCMP. And almost every single one of them, they say, oh, yeah, we agree, and we're going to do something in this regards, or we're going to try and fix it. I guess I'm going to ask whether or not you feel that their responses are going to equate to the actual actions, like their words are going to match the actions when they didn't have some of the goals. Because didn't you say that earlier that when they came up with their goals as to how many people, because we've got this massive shortage in recruitment of officers, and their goals were not to fill those positions that we figured that they need, but their goal was to match how many they actually had to the funding that they figured they could place on that.
So I think there's two parts to your question. The first would be recommendations. I believe that a response to a recommendation should have a statement of agreement or not, and in a clear timeline and some clear actions. So the RCMP could have given us better responses, but this is where I encourage the Public Accounts Committee to invite them to study our report, and then they will be required to give you a detailed action plan. So that would be my recommendation on the responses. When it comes to identifying their needs, they set a target to recruit 1,280 police officers based on what they believed they could train, the funding and the ability they had to train them. That number is well short of what they need. And so you're not even aiming to recruit to meet your needs.
Yeah, can I just get a little more detail on that and how they came up with that number? Because in the report, it came out that it says 247,000 is the figure that it costs to recruit and train an RCMP officer. But we had a discussion earlier about how there's fixed costs and there's a per member cost in some of those. And so when they're doing this, calculating out that they can only do this, it's much more efficient if they actually had their full training amounts to get those people trained, because then those fixed costs would actually go down. So our per recruit costs would probably go down. Is that not correct?
Absolutely. The per recruit costs would go down if you could fill up the training classes and then graduate more cadets out of there. So the cost, the way they determined the 1,280 was what they have as capacity. So what they have at depot, and how many they could put through there. You already have a trainer. You have a classroom. So if you
and they said that their maximum per year is 1,600 that they could probably do, but they're significantly less than that. And you'd said in
Mr.
your earlier...
just a very quick question. Your time is up. So
okay.
if you want to ask...
I was just going to ask about where the bottleneck is in the application process that needs to be improved the most.
Bottleneck starts for sure with the fact that it takes 330 days on average to process an application. And if you tackle that, you'll increase that. But eventually, you'll need capacity to train.
Thank you. And then lastly, Mr. McKinnon, you have the floor for 5 minutes. If you...
And thank you all for being here, and thank you for your diligent work on all these files, all of you. I'm going to go back to bottlenecks, but I'm going to pay system again. So progress to simplify and standardize pay rules and processes has been limited. Is there any particular bottleneck, any particular impediment to making progress in this area?
Well, I mean, I think it's in everyone's best interest to make sure public servants are paid on time and accurately, and how the government goes about doing that to simplify pay rules is up to them. Right now, it is trying to work with the unions to negotiate and figure that out. There's been one element that was worked on, and they're still working on fixing other simplifications. There is a memorandum of understanding that's been signed between Treasury Board and the unions, so that this can be done even between collective bargainings, right? I think everyone's goal is just to try and avoid many pay errors once we move to the new system. So I think it's definitely a great question for Treasury Board, one that I can't tell you why it's slowed down, but they have made limited change, and as a result, customization is needed, which comes with an annual cost.
So, if I understand, you're not saying that it's a lack of resources on the government side. It's more about negotiations with the unions and
I don't know why they haven't made progress. I don't typically talk about what the central agencies and unions discuss. I can just give you the facts that they wanted to simplify pay rules, and there's been very few done. So as a result of mitigation strategies in place, which is customizing day force to compensate for those.
Any particular department that is more problematic than others?
In terms of complexity of payrolls?
Well, in making some progress on
Oh, again, I have no clue. I think that would be a question for Treasury Board Secretariat as to what have they been trying to simplify. But I think they're looking at bigger, broader things, sort of how acting pay is handled across the public service. And that's not unique to one department. That is something that is bigger and broader across the public service. I guess finding out what their priorities would be, what they're trying to focus in on first, would be a great way to know whether or not there has been a particular department that's slowing this down.
Well, I understand this is going to be critical going forward with the Dayforce system. I guess perhaps you could sketch the timeline of how that system is developing and where it is?
Well, I'm not usually one to guess. What I can tell you is what the government's put out as their timeline. They had a plan to transition all of the departments by 2034. They shortened that by 3 years in January of this year, so now they want to do it by 2031. The first 3 departments are expected to transition in 2027. And so what we're seeing different here from Phoenix is there is a small wave at the beginning, and then I would expect to see some adjustments made. And that's why it's important to have a lot of vigilance around monitoring the existing risks that they know and that we have flagged in this audit, but then emerging risks, risks that may come because of reductions because of the comprehensive expenditure review or for early retirement. All of those will add to pay transactions and complexity, and they need to be factored into timelines as you move forward.
So I understand the transition is going to be not one fell swoop, but it's going to be gradual, few departments at a time. So
definitely different than what we saw back in 2016.
Okay. So these changes in payrolls and such could be done as they transition into the new system on a department-wise basis? Department by department basis?
Well, I think it's a little more complex than that because of how the collective agreements work. It isn't as simple as just simplifying a payroll and then fixing it. It'll be about when all the collective agreements get renewed and how it gets impacted. So simplification is not simple, unfortunately, with payrolls.
So a lot of this complexity in the payrolls and processes is wrapped up in agreements with unions and so forth.
Well, complexity is in some of the collective agreements around payrolls, but the complexity of the processes is well within the government's control. Dayforce is also replacing about 30 HR management systems. This is one government, and across 49 departments, there's 30 HR. Different 30 HR management systems. So standardizing that and will help as well, right? So I think there are really 2 ways of going about making HR to pay simpler. It's not just payrolls, but it's also about all the processes within the federal public service.
Thank you. I believe that's my time.
You will ask a small question, or are you done, Mr. McKinnon?
Well, I was going to say that since the processes are within the purview of the government to do, it's not a matter of negotiation. Is there any particular bottleneck there that we can talk about?
So I'm not sure about a bottleneck. I think it was a decision made on timing. The government had identified about 250,000 processes that they wanted to standardize across the public service. They've made progress on almost 200 of those, but no department is expected to adopt these new standardized processes until they migrate over to Dayforce. So again, that might be something they want to think about, whether there's merit in doing that earlier. No, 250 different HR to pay processes.
I was scared there. Okay.
That's okay. But it just shows you how complex it is and how it's really a shared responsibility between departments and agencies, as well as the central agencies that manage the actual pay system, to make sure that employees are paid accurately and on time. Well, we're on the right path right now, but there are still many public servants who have been underpaid or overpaid and need corrections to their pay. So clearing out that backlog, especially the older ones, is critical.
Thank you.
Thank you. I want to thank all the witnesses from the Office of the Auditor General for your testimony and participation in relation to the 2026 Spring Reports of the Auditor General of Canada. we'll see you back for additional studies in the coming weeks and months. This brings us to the end of our first hour. I'll suspend briefly to bring in our next.
Okay, so we're going to call it here. I've put the link in chat for QP, but I don't think Carney's going to be there, and I don't think Pierre's going to be there. Pierre might show up, but I'm not 100% sure. I know Carney's not showing up. In fact, Carney hasn't released his itinerary for over a week now. So, yeah. What the hell? The stream just closed on me? I don't know. I think YouTube's been having some issues because I couldn't even get the chat up on my phone. It was acting weird today. But, yeah. There's the link again for question period, guys. Thanks so much for tuning in and watching. Thank you, Wickeden. I think you left already, but thanks for staying in the club. Thank you, Miss Canadian, for staying in the club. Thank you, Raven. And thank you, Megan, for gifting 5 memberships. Really appreciate you guys. And with that, I will see you guys shortly. If you can't make it for QP, then we'll be committee in the afternoon with the new PBO or prospective new PBO. So I will see you guys soon. Bye, guys.